Oracle and SAP were sued earlier this year. What lessons can you learn from this and what can you take away? That's what I want to talk about today. My name is Marcus Harris. I'm a software and technology attorney for over 20 years. I've drafted and negotiated a variety of technology and software-related agreements and litigated failed ERP software disputes in courts across the country. Early this year, SAP and Oracle were both sued, and there are certain takeaways that I want to talk about, and I think there are certain lessons learned from each of these pieces of litigation. Let's talk about the SAP litigation first, and this is Celonis Inc. versus SAP. And what this is really about is who controls the data that you put into your ERP system. And SAP, no doubt, wants to have essentially sole control over the data that you put in there. They want to prevent third parties from being able to access and utilize that data to be able to provide services to you. So Celonis is a data process mining company, and it's got some history with SAP, but I think for the relevant facts related to this discussion, it really is a scenario where Celonis makes most of its revenue, as they've asserted in their complaint, from accessing and then providing analysis with respect to the data that their customers have put into their SAP system. And SAP is now trying to prevent or limit Celonis's access to that data. And essentially what SAP is doing, as it is alleged in the complaint, is they are charging their customer or charging fees really for the access and utilization of that data. And these fees, according to Celonis, are exorbitant and are going to have a massive impact on its business. So, this is winding its way through the court system, but I think really, the biggest takeaway from this is really the broader implications. And as we move forward with artificial intelligence and, your ability as a customer to be able to utilize that artificial intelligence functionality from a third party in connection with the data that you own, that you have inputted into that SAP system, what flexibility are you going to have to be able to do that? And I think, if this Celonis lawsuit is any indication, and we have seen this in practice, SAP is trying to put a fence around your data. So not only is it going to be data process mining providers that are going to be precluded from accessing this information, but it's also going to be artificial intelligence providers that are going to be prevented from utilizing this information. And I think this is really not that surprising, and it really kind of goes hand in hand with this indirect access issue that was a hot button item a few years ago, maybe more than a few years ago with SAP. And that issue was essentially SAP wanting to charge licensing fees for any third-party application that was coming into the system and pulling data out. So this is essentially a similar scenario, but I think it's more relevant today than it has ever been in its implications with respect to artificial intelligence and third-party data analysis and data providers. Make no mistake about it, SAP is really trying to design some kind of a vertical system where you're disincented from using these third parties so that it can then sell to you its own applications. It's going to have its own artificial intelligence application. It's going to have its own data process mining application. And that really is what SAP's end goal is here, is to prevent you from utilizing these third parties and generating revenue, them generating revenue from you, where SAP wants to keep that all for itself. And I think this case will be interesting to see what the parameters of SAP's restrictions are going to be, what it's going to be allowed to do, and what kind of flexibility you're going to have as a customer. The other interesting case filed earlier this year is a case filed by a company called Veronica's Auto Insurance against Oracle and NetSuite. And this is more of a traditional ERP software implementation dispute type of lawsuit, and Oracle has a long history of being subject to this type of litigation, and this really kind of follows a familiar path. Here, Veronica's Auto Insurance really made allegations of false misrepresentation, overselling the software. Oracle made a variety of representations during the sales cycle that just didn't end up being true. First, they assured Veronica's Auto Insurance that the software was tailored to the insurance industry when it apparently wasn't. They then told Veronica's Auto Insurance that the software was going to be implemented in full Spanish language. Apparently, many of the employees, or most of the employees of Veronica's Insurance, only spoke Spanish, so the English language version of the Oracle software was going to be primarily useless to them. And the other allegation of misrepresentation made by Veronica's Auto Insurance was that Oracle told them that the software did not or would not require third-party add-ons. And as they went through the implementation process, each one of these turned out to be untrue, as they allege in the lawsuit. And of course, Oracle disputes this and has filed an answer and a response. The allegations in this complaint really are breach of contract, breach of the implied covenant of good faith and fair dealing, fraudulent and negligent misrepresentation. And these are really the standard allegations that you're going to see in these types of lawsuits. They will vary depending on the particular facts. You might have some sort of unfair competition claim. You might have some sort of statutory claim with respect to unfair business practices. In certain scenarios, you might even be able to bring some sort of professional negligence claim against the consulting company that did the implementation or integration project. So there are a variety of ways and strategies that you can employ to deal with these aggressive sales tactics. And I think the takeaway really is kind of more of the same, right? If you're dealing with an aggressive sales process, you're dealing with aggressive salespeople, you've got to take what they say with a grain of salt. You've got to really question this. It really is caveat emptor. They are incented to tell you what you want to hear. They are going to oversell that software. They're going to sell you the sizzle. There may not be any stake behind that. They're going to show you shiny objects, and it's going to be tailored. This software demonstration, for example, is going to be tailored to all of the problems and issues that you have told them about, and that software is magically going to be able to address most of those issues and concerns that you have, and that certainly is by design. And so I think the way out of this is really to hold their feet to the fire. You've got to take every advantage of that sales cycle. You need to check on references. You want to do site visits. You need to look at the product roadmap to make sure that you have an understanding of what the functionality is in that software today. You want to know what functionality is going to exist in the next 3 to 5 years. You want to make sure that what they've shown you actually exists. And I think you, to a large extent, are at a disadvantage in that scenario because they're not incented they're not looking out for your best interest, and that really can be a problem. But I think you've got to get a good team on your side. You want to get software selection consultants. You want to get experts. You need to have certainly good legal representation to go through these contracts and to try to nip these things in the bud so that you have a dog in the fight if you have to actually litigate against Oracle, which is a position you don't want to have to be in. I hope you found this information useful. If you have any questions about anything I've talked about in this video, please feel free to reach out to me. I'd love to talk to you. You can reach me at taflaw.com. Thank you.